I want to backtrack a little. I want to give the family law perspective and the judge's perspective. Once an appeal is filed, I mean, judges were taught that once an appeal is filed, you're divested of jurisdiction. And sometimes things come up in child custody cases, in these types of cases. So the judges have to follow the rules strictly. Once you're divested of jurisdiction, you cannot take actions, issue any orders. There is an exception. I don't know the name of the rule. Marshals can quote it. Child emergency, jurisdiction. If there's an exception, the judge can step in to protect the safety and well-being and the best interests of a child. But yeah, that's kind of a last resort.
That's the Manley rule for short-term emergency orders for the safety and welfare of a child.
Exactly. But what's the NRAP rule? There's an NRAP rule for that.
It's not so much part of the rule structure, but under the case law, really.
I see. Okay. So once the appeal is filed, the judges can't do anything.
It sounds like if there's a real emergency, then they can come back to the judge and say, hey, we need you to consider this under this particular case law. But otherwise, once we've got this appeal going, the Supreme Court or the Court of Appeals is on it until a decision is made, correct?
Right. That doesn't mean that you're totally outside the district court. If you have to, if family law is one of those places where things change on the ground. And if the situation on the ground is such that basically the appeal is ridiculous for some reason, because the order should be changed again, and it seems clear, then you have the ability under a procedure called honeycut to go up to first you go to the district court and you say, district court, if these ABC facts were different, would you enter a different order? And the judge says, well, yeah, now that this has happened, I would do that. Then you can go to the Supreme Court and say, would you please send the case back down so the judge can change the order and it may make the appeal go away. And if they agree, they send the case back down and the judge can make a different order. And the appeal sometimes is resolved right there and right then because it no longer makes sense to even go forward with it.
So the practice tip would be to file a honeycut motion on an order shortening time, get before the judge. The judge can well, it's not certified, but issue an order saying the court, if this was entertained, this motion was an emergency motion was entertained, I would be more likely to grant it or not grant it. If it's more likely to grant it, then that pronouncement by the trial court would go up to the Supreme Court to let them know if they would lift the stay to temporarily address the issue. But that's correct. The attorney should file a honeycut motion, not expect the judge to just issue an order while this appeal is going.
Two other things to point out, especially because family court cases often deal with so many different issues. So if you have a decree of divorce with property issues, alimony, child support, custody, and somebody appeals only one or some of those issues, the other issues, the district court is not divested of jurisdiction on the other issues. So if I file an appeal on custody and someone wants to go in and modify alimony, the district court can absolutely modify alimony if alimony is not on appeal, only custody is. In addition, the district court can always still enforce the order. So if I appeal child support and the other side wants to go in and enforce non-payment of child support, they can still do that even for the order that's on appeal.
Well, my understanding, Emily, was that I would still require the honeycut motion, at least when I was practicing on the bench. That we absolutely, I mean, I took the rule strictly. The Supreme Court is kind of, when they used to go to family law, I mean, the family law judges conference, they would say, once an appeal is filed, you're divested of jurisdiction. So you have to take the formal process, and the better practice, I guess, suggested practice is to file that honeycut motion and get that pronouncement from Supreme Court to give you the green light to go ahead and have the judge rule on that independent collateral issue.
The honeycut motion is only required for the issues that are on appeal and to modify them. So enforcement or modifying issues that are not on appeal doesn't require it. I mean, if someone wants to go in and include that analysis in there, it doesn't hurt, but it's not required.
Yeah, I agree. Some judges are just awfully gun shy and refuse to hear anything about anything while an appeal is on file. And it's a little bit exasperating. I've had several honeycut motions where I've gone to the Supreme Court and said, well, I don't think I should be here on this, but the judge made me. And the Supreme Court has said, you shouldn't be here on this. Why are they making you do this? Well, that's what the judge said to do. So here I am.
Oh, really?
It's happened.
So I mean, it can be pretty nuanced as to what issues are still down below with the district court judge, and then what issues may actually be on appeal. If you only do a limited appeal, then it can be bifurcated a little bit in that way. And I could see where the district judges would, district court judges, would, well, we want to be cautious rather than, presumptuous, but certainly it's a challenge. Sometimes it sounds like, and making sure to file that motion is probably going to be that's your way into court anyways, is to file a motion to get the court to make a decision either way, right?